books. But first, A.E. Dick Howard on his book, The Road from Runnymede, on the Magna Carta's influence on the Constitution.
Ladies and gentlemen, happy Bill of Rights Day. And this is no ordinary Bill of Rights Day. On December 15th, 1791, the Bill of Rights was ratified and made part of the Constitution. This day and this moment is, in fact, the 225th anniversary of the ratification of the Bill of Rights. A round of applause for the Bill of Rights. I am Jeffrey Rosen, the president of this wonderful institution, the National Constitution Center, which is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And we have a thrilling Bill of Rights Day. We've got a blockbuster show of 4 marvelous books about the Bill of Rights. You will hear about the origins of Magna Carta, about Madison's notes and his efforts to change his own role in the drafting of the Constitution. You'll hear about the value of dissent throughout Supreme Court history, and you'll hear just a great book trying to channel the writers of the Federalist Papers and to imagine what they would think about current controversies. So it's going to be a wonderful substantive day. I am so excited to introduce Bill of Rights Day by introducing you to a magnificent new interactive tool that the National Constitution Center launched on Constitution Day and is now thrilled to distribute to every student in America from 8 to 80. And I want all of you and I want our great C-SPAN viewers to follow along with me as I show you this remarkable nonpartisan tool and tell you what it can do. And it's also the perfect introduction to our first panel about the relationship between the Magna Carta and the Bill of Rights. So the Interactive Constitution, which you can find on constitutioncenter.org, is an exciting project that's a collaboration between 3 great organizations: the Federalist Society, the American Constitution Society, and the College Board, which has decided to make this a centerpiece of the new AP History and Government exams. And what we've done, with the help of our great partners, is to ask the leading scholars in America from every perspective, liberal and conservative and everywhere in between, to write about every clause of the Constitution, describing both what they agree about and what they disagree about. So when you go to this great site, you can be confident that when you read the common statement about what the scholars agree about, this is a bulletproof, bipartisan statement in which scholars of the greatest divergent perspectives agree. It's like a unanimous Supreme Court majority opinion. And then you can read their separate statements, which are like separate concurrences. So it's Bill of Rights Day, and here we have not only the first 10 amendments, which are the Bill of Rights, but right now all 15 amendments, and we're building out the rest of it over the next few years. Let's begin with the 5th Amendment, which says a whole lot of things, but it includes what's called the Due Process Clause, which says that no person shall be deprived of life, liberty, or property without due process of law. What's the core meaning or historic sources of that clause? Well, you can click on the common statement, and you'll see Roger Fairfax and John Harrison, 2 of the leading scholars of the Due Process Clause from divergent perspectives, telling you that, and I'm reading now, the principle that government should be limited in how it makes its decisions is very old in Anglo-American law. The Magna Carta, a statement of subjects' rights issued by King John of England in 2015, became well known over the centuries. Chapter 39 provides that no free man shall be arrested or imprisoned except by lawful judgment of his peers or by the law of the land. This language gave rise to the concept of due process. How exciting. And then read the rest of this statement and you'll hear about the development of the Due Process Clause, its current controversies, and then you can read Professor Fairfax and Professor Harrison with their disagreement about how the 5th Amendment should apply today. So this is just a magnificent introduction to the Due Process Clause. But that's not all. With this great tool, you can not only buy a Ginsu knife, but you can explore the actual Revolutionary era state constitutions, as well as the sources in English common law that gave rise to the Due Process Clause. So you can click on Writing Rights, And we want to begin with the Fifth Amendment, because that's the one that we're talking about. And here, you'll see the authoritative sources that James Madison relied on when he wrote the Bill of Rights. He didn't make these rights out of thin air. He cut and pasted from Revolutionary-era state constitutions and from English common law sources, including, most significantly, the Magna Carta. So here we can click on the Magna Carta and see the language of Article 39. No freeman shall be taken or imprisoned or disseized of his freehold or liberties or free customs or outlawed or exiled or any otherwise destroyed, nor will we pass upon him nor condemn him, but by lawful judgment of his peers or by the law of the land. And then you can trace the evolution of that language through Madison's first proposal, which doesn't look exactly like the Fifth Amendment as it ended up. His first proposal, it looks like, doesn't even... here it is. It's the due process clause is not shall not be a witness of himself, nor deprived of life, liberty, or property without due process of law. And then we can compare Madison's first proposal, which does contain that language, and then you can watch it as it moves through the Senate and through Congress and ends up in its final form. So this is a magnificent tool not only for studying history and government, but also language arts. And the head of the College Board and I hope that students from 8 to 80 really can engage with the text and carefully follow the evolution of this great principle. But there's one final and exciting thing that this magnificent tool can do. We've already started with the contemporary agreement and disagreement about the Due Process Clause. We've moved back in time to see its roots in the Magna Carta and in Revolutionary-era state constitutions like the Virginia Bill of Rights, which has a phrase that says that no one can be justly deprived of his liberty except by the laws of the land or the judgment of his peers. Isn't it interesting that the Virginia Declaration from 1776 has language which sounds even more like Article 39 of Magna Carta than does the final draft of the Fifth Amendment itself? But not only can you start with the present and go back in time, but now you can trace the spread of these liberties across the globe. And in this astonishing final platform, which we call Rights Around the World, you can click on the due process guarantee, which is right here, and you'll see the due process clause. And then you can see every other country in yellow that has a version of the due process clause. So if you click on the United Kingdom, of course you find both the Magna Carta, Article 39 itself, as well as the Human Rights Act of 1998, which says that no one shall be deprived of his liberty save in the following cases, and it gives examples. So how interesting to compare the historic sources with the contemporary exploration. And then you can click on other countries that protect due process as well, including Germany, which says in the courts, every person shall be entitled to a hearing in accordance with law. How wonderful it is to see international visitors to the Constitution Center see this platform, which you can access in our beautiful Bill of Rights gallery, which has one of the 12 original copies of the Bill of Rights, and pick a right that interests them that's in the American Constitution and compare it with the way their Constitution protects these rights. And an exciting new Constitution drafting lab that Google has helped support at the Constitution Center, we're bringing together drafters of constitutions from abroad and school kids to compare American constitutionalism with the way these rights are protected around the world. So it's an incredible tool. We hope that it will transform constitutional education in America. We want to bring it to every student in America, so I want you and I want our C-SPAN viewers to check it out, constitutioncenter.org, dig deep into it, compare the historic, contemporary, and international sources of our rights, tell us what you think, how we can improve it, and let's work together to transform constitutional education in America. And with that enthusiastic introduction, because as you can tell when I show this platform, I get very fired up, it's now my distinct honor to introduce the leading scholar of Magna Carta in America. We are so lucky to have Professor A.E. Dick Howard kick off our Bill of Rights Day. We've been eager to get him to the Constitution Center for a long time, and there's no more auspicious moment and no more distinguished scholar than to begin our proceedings today. He is the White Burkett Miller Professor of Law and Public Affairs at the University of Virginia School of Law. He was a Rhodes Scholar and law clerk to Justice Hugo Black on the Supreme Court. One of my favorite justices, one of my sons, is named Hugo in honor of Hugo Black. Hugo Black was a great, there was a Hugo, we needed two names because they're twins, and there was a Hugo Black biography lying on the floor, so we sort of picked Hugo. And he's a hero because Hugo Black was a great textualist who really believed in enforcing the Constitution, and he believed in the First Amendment more passionately than anyone else. Professor Howard has consulted with state and federal bodies. He's often consulted by constitutional draftsmen in other states, and he's helped draft constitutions in Brazil, Hong Kong, the Philippines, Hungary, Czechoslovakia, a real internationalist and statesman. He's briefed and argued cases before the Supreme Court, and his many books and articles include The Road from Runnymede, Magna Carta and Constitutionalism in America. Ladies and gentlemen, please join me in welcoming Professor A.E. Dick Howard.
Thank you. That was an enthusiastic introduction. I just wish I could kick off my classes at the University of Virginia with the same kind of enthusiasm. Jeff has certainly alerted you to the reason why we're starting Bill of Rights Day with Magna Carta. I mean, otherwise it would seem a fairly idiosyncratic choice, an English document 800 years ago. You know, what's it got to do with the Bill of Rights? Well, the road to the Bill of Rights really begins in many ways with Magna Carta. As many of you know, this is the 800th year since Magna Carta was first agreed to by King John at Runnymede. Indeed, I was at Runnymede on June the 15th of this year, the exact anniversary date. So I come back with a sense of why the English were celebrating it. It makes great sense that they would be making a lot of this anniversary. But the question I want to put to you and talk about this morning is, why should we care? You know, why should we care about this bargain struck between a reluctant King John and these aggressive barons at Runnymede in the year 1215? Well, the story takes us back to and begins with King John himself. I first met King, well, actually, I didn't really meet King John. That would be a little bit of a stretch. My students think I was at the Philadelphia Convention, but I wasn't there either. But I was first introduced to the idea of King John when I was a kid. And my parents would read to me, and one of the books, you know A.A. Milne, the creator of Winnie the Pooh. I'm sure many of you are Winnie the Pooh fans. He also wrote a wonderful little book called Now We Are Six. If you don't know that book, for your children and grandchildren, it's a wonderful read. And one of the poems in there is called simply King John's Christmas. And that poem begins something like, King John was not a good man. He had his many ways, and sometimes no one spoke to him for days and days and days. Well, you know, you're a little kid, and the idea of being shunned like that, nobody will speak to you. I mean, this is pretty bad. Well, I grew up. I said, you know, nobody could be as bad as that. Well, I grew up and started reading about King John, and he was that bad. Maybe worse, in fact. He certainly was morally corrupt. It's no accident that no king of England has ever been named John since that King John, and there never will be one. He was not only morally bankrupt, but also the most inept king, perhaps, of almost any in English history. He was a terrible military leader. At the Battle of Bouvines in 1214, he lost most of the Normans' landholdings in France to the French, and that didn't endear him to the barons who were landholders. He quarreled with the Pope over the appointment of an Archbishop of Canterbury. He finally had to give in to the Pope's wishes. The townspeople were against him. The town of London went over to the barons' cause. But above all, he had made enemies among the barons themselves. These were really the makers and shakers of their time. They were the potentates. And he was always leaning on them for money. Kings always needed money and to finance his military adventures and the like. And he would pluck money from them in ways that were not consistent with English custom and practice. Well, finally, all these forces ganged up on him, and the result was Runnymede, June the 15th, 1215, where the barons came, presented their demands, and John reluctantly acquiesced. Now, I'm not going to walk you through the provisions of Magna Carta. Most of it's about feudal relationships and things that need not concern us. But the centerpiece of Magna Carta is the one that Jeff already pointed to, and that is what was called Chapter 39, and that's the one that provides that no one shall be proceeded against except by the law of the land. And law of the land came within a century or so after Magna Carta to be interchangeable with what we today call due process of law. So when you read the 5th or 14th Amendments due process clauses, you will see a concept which traces directly back to Magna Carta. So that was where it all started. Now, Magna Carta could have died. In fact, the King John, got the Pope to annul Magna Carta. So within a couple of months, it was a dead letter. And if that was all there was to the story, I mean, I wouldn't be up here this morning. We wouldn't be talking about Magna Carta. But King John died the next year, 1216. One of the chroniclers records that he died of a surfeit of peaches and new cider. So if somebody offers you that at one of the Christmas parties you're going to, I think I'd push the plate away and say, no, thank you. It was not good for King John. It's not good for me. So he died the next year. His successor, Henry III, was 9 years old. Now, this is the Middle Ages. How long is a 9-year-old kid going to, will he live to be to his majority? Maybe so, maybe not. You've all seen Game of Thrones. You know what that period in history was like. Well, his regent, William Marshall, a remarkable man, hit upon what I think we today would call a public relations gesture. And he said, I will have, let's get this young prince, now king, to reissue Magna Carta. Well, they did that, and that set in motion a tradition that successive English monarchs would begin their reign by reissuing Magna Carta as a sort of statement of good faith to respect the rights and liberties of the English people. So that's where it begins. Now, one other mention of the Middle Ages, a century or two after Magna Carta, a statute was passed. I think it was basically an instruction to judges that said if Magna Carta and another statute were in conflict, that you would prefer Magna Carta. Magna Carta was thought to be better than or superior to other statutes. And that begins to set and train the notion, today we would call it constitutional or judicial supremacy. The notion of the Constitution as a super statute was already beginning to emerge even as early as the Middle Ages in England. Now, I'm going to pass over the Tudor period. I guess the reign of Henry VIII has never been thought of as a great time of constitutional government. Certainly the wives of Henry VIII wouldn't have thought that. So let me jump over to the 17th century. This is the century in which, of course, the first permanent English-speaking colonies were being planted in this continent. And it was also in England a turbulent period of civil war, of conflict of every kind. I think it must have been a dreadful time to live in England, because I take it the Civil War in England was as bad as the Civil War in this country. The century began in constitutional terms when Queen Elizabeth died and the crown went to James VI of Scotland, who became James I of England. So the House of Stuart came to the throne in England. Well, James brought with him a concept of the divine right of kings. Well, you can imagine that was not accepted as a traditional English precept. It was on a collision course with the rights of Parliament. One of the leaders of the parliamentary opposition to James I and his pretensions was Sir Edward Coke, spelled C-O-K-E, but pronounced Cook for whatever the reason. It's the English language. They do what they like with it, I guess. So Sir Edward Coke was the leader of the opposition, and during debates in Parliament on the king's prerogative pretensions, Coke said, Magna Carta is such a fellow, he will have no sovereign. In other words, that even the king was limited, Coke argued, by the precepts of Magna Carta. Well, so it was a turbulent century. Struggles finally led to civil war in the 1640s, and in 1649 the execution of Charles I, which brought into being the Cromwellian Commonwealth, You and I live in commonwealths, Commonwealth of Pennsylvania, Commonwealth of Virginia. That name has its early origins in the 17th century. Well, after the Cromwellian regime, the Stuarts came back to the throne in 1660. Struggles continued. There were still debates between the crown and parliament. Finally, what Whig historians used to call the Glorious Revolution, 1688, which brought William and Mary to the throne, put an end to the Jameses and the Charleses, and William and Mary, as a part of the constitutional settlement, agreed to the great English Bill of Rights. 1689, the Bill of Rights of England, which in so many ways prefigures, anticipates, is a model for our Bill of Rights. If you lay the two documents side by side, you'll see provisions of the English Bill of Rights that have been carried word for word over into the American Bill of Rights of our own Constitution. So that's basically what was going on in England in the 17th century. And let me at that point take the story over to the American side. Because as I mentioned, when all this constitutional refiguring was going on in England in the 17th century, the American colonies were getting their start. Each one had a charter. Virginia, for example, the first of the permanent colonies, 1607, operated under the Virginia Company Charter of 1606. And most of that charter is about commercial matters. Everybody thought they'd get rich discovering gold and silver. And I don't know if you visited Virginia lately, but you're not likely to see a great deal of gold and silver mined down there. They did find tobacco. But a provision, aside from all the commercial provisions, the most interesting line in the Virginia Charter guarantees to those who immigrated to Virginia the privileges, franchises, and immunities that these colonists would have enjoyed in the mother country. So the idea was if you pulled up stakes and moved to this wilderness called Virginia, you didn't leave your rights behind. You brought them with you. Now, one might fairly debate what was the content of those rights, but they clearly understood it to include the guarantees of Magna Carta. So I could tell you stories which time won't permit this morning, but I could tell you a number of stories about ways in which colonists during the 17th century in places like Massachusetts, here in Pennsylvania and elsewhere, insisted on the rights of Magna Carta in struggles with their own governors and their own courts and the other colonial institutions. So Magna Carta and the English common law were being thoroughly infused into American law. Not surprisingly, these were, after all, English colonies. So Magna Carta was becoming part of the common language of American law and constitutionalism. In the 17th century, the foundation was laid. Let me then suggest how you get from the early period to the revolutionary period. Starting in about the 1760s, the pot was boiling, and there was a famous case argued in Boston in 1761. James Otis, arguing the famous writs of assistance case. He was representing Boston merchants who were objecting to writs of assistance were sort of like general search warrants. They were not limited. They wouldn't satisfy today's Fourth Amendment requirements. They basically allowed officials to go in and search your house or your place of business for anything they wanted to do, anytime, any way. And so Otis said, this is not constitutional. At this point, there was no written constitution. This is still the colonies. But he was making a case that we today would recognize as being a constitutional case. And he cited Sir Edward Coke. Remember, Coke is back in the early 17th century. Coke had decided a case in 1610 called Dr. Bonham's case. And in it, there's language where Coke says that an act of Parliament against right and reason is null and void. Now, that doctrine never really took hold in England, but Otis proclaimed that to be part of the fabric of British constitutionalism in opposing the writs of assistance. Now, in London, the Privy Council, the government, the cabinet couldn't make sense of arguments like Otis, because over there, by this point, you had Blackstone's commentaries, William Blackstone's great commentaries on the laws of England were written in the 1760s. And in it, Blackstone says, Parliament is supreme. Parliament makes the law. Parliament calls the shots. And he didn't recognize judicial or constitutional limitations on what Parliament could do. Parliament might pass crazy laws, immoral laws, unjust laws, but they were law. So here's Otis on the other side of the Atlantic saying there are constitutional limits on what Parliament can do. So you have, on the two sides of the Atlantic, two quite opposing points of view. Small wonder that the revolution finally came about because the English and the Americans were really talking past each other. Now, the story after that is a very familiar one, especially to a Philadelphia audience. Stamp Act was passed in the 1760s, the first time Parliament had sought to impose an internal tax in America. It had external levies, but never internal, and you know how the American colonists reacted to that. No taxation without consent. They also complained that trials of these cases under the Stamp Act would be in admiralty courts, and admiralty courts had no juries, and the right to trial by jury was one of the rights that Americans traced back to Magna Carta. Well, the Sons of Liberty then threw the tea into the harbor in Boston. You know that story. Well, that touched off a firestorm. The British closed the port of Boston. They quartered troops on the populace in Boston. They dissolved the Colonial Assembly. And these actions, which the colonists call the coercive or intolerable acts, sparked cooperation on the part of all the colonies. The other colonies came to the support of Massachusetts in the Continental Congress. And in that process, they wanted to frame their opposition by way of resolutions. They wanted to say, how is it that we Americans have come to have these rights that we're proclaiming against the British? Well, there was an interesting debate that went on in the Continental Congress. Some people said we ought to point to the charter language like the one I just quoted. Others said we ought to put it on Magna Carta and the British Constitution. And yet others said it's natural right, it's natural law, it's the will of God. Well, these are rather different ways of thinking about rights, but being Americans, we're such an eclectic people, they decided rather than choose one or the other, they would sweep them all together into one basket. And so they based these claims of rights on all these different sources. If any of you are lawyers or have studied law and you find American constitutional law to be messy, well, we've done it that way for a long time. We're not like the French, who are very analytical and organized in their legal thinking. We just got to take it in sort of a bundle. So that was the Continental Congress and its resolutions. Now, with independence, with the beginning of the Revolutionary War,